Welcome, my name is David Ricks. I'm a personal injury trial lawyer in Rancho Cucamonga and the principal of the Inland Empire Law Group. We often receive cases into our office where one of the questions that we get is whether or not that person's case will go to trial. And at the very beginning, it's sometimes very difficult to answer that question directly. But here are 4 or 5 ideas of why a case may or may not go to trial. Number 1. The plaintiff or the person who was injured has to prove negligence on the part of the other individual or multiple parties. In that situation, if the negligence or responsibility is fairly clear, that issue basically gets taken off the table. But if the negligence of the person is in dispute, such as a situation where 2 people come into an intersection at the same time and both claim they had a green light, then there's a possibility the case may go to trial. Now, many things go into that evaluation, but that's the first thing to look at, whether or not the liability or the negligence is established and clear. That'll determine whether or not a case may go to trial. Number 2, causation. Whether or not the accident caused the injuries that the person is claiming. That's an important part because many times a person's injured, but those injuries may not have been directly related to the accident. They might be a pre-existing condition, they might be a subsequent condition that occurred, there might be a lot of other things that happen, and so the defense will argue that the injuries claimed were not caused by the negligence of their insured or of the person that you're claiming is responsible for your accident. So that's the second thing that may go into analysis of whether or not your case goes to trial. Number 3 is damages, and oftentimes this is the biggest one because the person who was injured has a level of expectation of how much they want to recover from their injury. And that level of expectation may be much higher than what the defense or the insurance company for the defense wants to pay. For example, if the person thinks their case is worth, let's say, $100,000, but the insurance company thinks the case is worth $10,000, there's a $90,000 gap between those two. And unless the parties can negotiate and bridge that gap, the case has a high probability of going to trial. The fourth thing that you might look at is whether or not you can cost efficiently take that case to trial. If the costs are too expensive to go to trial, then oftentimes the case has to be settled in order to benefit the client or the injured party the most by getting them the most in their pocket following a settlement. So those are just 4 things to look at of whether a case may or may not go to trial. There are often many other issues involved, but those things will help guide you of whether or not your case may or may not go to trial in the future.